We will now move to the gentleman from Arizona, Mr. Stanton, for 5 minutes.
Thank you very much, Mr. Chairman, for holding this hearing, and to the witnesses for being here to speak to an important issue as we work to expand access to justice throughout our nation. When I became a member of the Judiciary Committee 2 years ago, one of the very first things I did was to meet with the Chief Judge for the District of Arizona, Judge Murray Snow, and I asked him, how can I help? Right away, he told me about the caseload issues in Arizona and how Congress could do more to expand access to the judicial system to communities around the state. I've been working on this since, and I know that if it weren't for the pandemic, that this is a hearing that we would have had last year. This is a pressing issue in Arizona, where the state makes up a single judicial district. Since the year 2000, Arizona's population has grown by 50%. More people have moved to Arizona in the past 20 years than live in the states of Rhode Island, North Dakota, and Vermont combined. That means the criminal and civil caseload has gone up too, and in that time, we've only seen the addition of a single federal judge in our state, just one. Judge Humitua, as she mentioned, that means that Arizona's federal district judges see a weighted caseload of 800 filings each. The general standard is 430 cases per judge. So in Arizona, we are nearly double that. I'm encouraged by what the District of Arizona would do with more judges. The focus on increasing access to the courts for rural tribal communities is the right one. For those who haven't been to Arizona and may not be familiar with the Navajo Nation, it is the largest tribal land in the country. Its capital, Window Rock, is a 5-hour drive from the federal courthouse in Phoenix. Hopi lands are a 4-hour drive. That's a long way to travel for court. And yet, that is what tribal citizens must do unless Judge Humitua and other federal judges coordinate for the temporary use of a courtroom space with the magistrate judge in Flagstaff, Arizona. When this coordination does happen, and my understanding that it's about once per month, Judge Humitua must drive up from Phoenix, leaving her civil caseload pending to address the criminal caseload in northern Arizona. She does this because she's committed to providing direct access to those in northern Arizona, but it is not a long-term workable solution. We need a permanent federal judge, district judge in Flagstaff to handle the caseload that originates from Indian country in northern Arizona. That's what Arizona will get if we approve more judgeships. In turn, grand jury proceedings would be made up of peers that is more accurately representative of the community. And other district judges would no longer have to travel and leave other also pressing cases pending. Arizona desperately needs more federal district judges. The district court has been working with too little for too long at the expense of Arizonans who should have fair, unobstructed access to our country's judicial system. Additional judges, that's a good place to start. And I have a question for Judge Humitua. Are there any lessons that you can share from your experience as a judge of the Hopi Appellate Court that would inform why it's so important to appropriately staff courts that include Indian country land?
Well, thank you for the question, Congressman Stanton. When I was an appellate court judge for the Hopi Nation, it drew my attention to really the limited jurisdiction that tribal courts have, especially in the criminal context. As you know, in my written testimony, I outlined that the federal courts, we act as essentially a county court, handling violent crimes off of Indian nations, homicides, sexual assaults, domestic violence, and the like. And so when a serious crime is committed and it is not picked up by the U.S. Attorney's Office, then the tribal courts have to adjudicate those offenses. And there often are not enough resources in the tribal court itself to appropriately handle those kinds of cases. And in addition, in the civil context, where there is much broader authority for tribal courts, non-members usually are nervous about filing their cases in tribal courts. They would rather file them in federal district courts. And many of my colleagues know, and we do exercise in the appropriate instances, tribal court exhaustion. So we may see a case be filed in federal court in the first instance, which should land in the tribal court. And so we act as sort of a go-between. I also raised in my written testimony that recently, last Congress, in the Violence Against Women Act amendments, there was a contemplation that for cases that were brought of non-Indians committing domestic violence in Indian country, there was an idea that the federal court should act as a reviewing court, essentially an appellate court in some instances. So there are numerous, experiences that I draw upon from that. Thank you for the question.
Thank you very much, Your Honor. And Mr. Chairman, thank you for holding this hearing. I yield back.